Dear friends, ladies and gentlemen, it's really a pleasure for me to kick off our new webinar series, Embracing Global Markets. And this webinar series provided crucial market intelligence and information on regulatory requirements, helping European businesses and innovators to expand in fast-growing markets in Asia, Africa, and the Americas. Our objective is clear. With this webinar series, we would like that companies willing to expand internationally have all information and understand the regulatory framework they are going to enter. And if not, at least to know better where to go to ask for that information and tailor support. The final goal is to help European companies to grow faster and seize trade as well as other commercial opportunities they otherwise would have missed out on. But like always, we could not do this possible, of course, without you. So for these webinars, we build on the knowledge of distinguished experts and advisors of the Enterprise Europe Network that I would like to thank really for their support. And I will also like to extend my sincere gratitude to the European American Chamber of Commerce, who have put in countless hours to make this session possible. Many, many thanks. So we deeply appreciate your efforts and the opportunity to learn more about doing business in the United States. Please allow me briefly to introduce myself. My name, Natalia Martinez Paramo. I'm the head of unit of the Single Market Program, SME Pillar, Internal Market and Support to Standardization at the European Innovation Council and Small and Medium-Sized Enterprise Executive Agency, known as EISMEA, of the European Commission. And at EISMEA, what is our main objective? To help small and medium-sized companies to realize their full potential in today's global economy. And to do so, we manage a strong portfolio of projects in the field of business support, single market regulation, and innovation instruments. So what we do exactly in my unit? We oversee the implementation of the SME pillar, as I said, of the single market program. And what this SME pillar seeks to facilitate access to markets, to support uptake of innovation and address global and societal challenges, and also foster a favorable business environment and entrepreneurial culture. And to meet this objective, we manage the Enterprise Europe Network, the European Cluster Collaboration Platform, the Erasmus for Young Entrepreneur Program, internationalization, tourism, and many, many other projects strengthening the competitiveness of European businesses. And as just mentioned, one of the objectives is to facilitate the access to market. And how do we do it? Through the EN, through our network, through Enterprise Europe Network. The Enterprise Europe Network is one of the flagship projects managed by my unit and one of the world's largest service providers for businesses with international ambitions. The network, Enterprise Europe Network, is composed of organizations from EU members, from associate countries, and also by our international network partners. And the network helps companies innovate and grow on an international scale. The network establishes a vast global commercial platform for businesses to trade and engage in research and innovation cooperation. And initially set up to exploit the opportunities of the EU single market, the Enterprise Europe Network has become a gateway to other exciting growth markets in Africa, Asia, and the Americas through our international network partners. And the success of the Enterprise Europe Network is based on the capacity of our over 3,000 network advisors to deliver tailor-made services of excellence to local businesses. But let me say this very clear. So I regard the participation of our international network partners from countries such as the United States, Canada, India, or Singapore, and many, many other countries, I cannot count all of them in my opening, is crucial success factor for our Enterprise Europe network. Our network partners in these countries help European businesses and startups to grow and scale in vibrant international markets. And in return, our European network partners support companies on all continents to enter and find businesses partners in the EU single market. So I strongly believe in the mutual benefits of international trade and commerce, and that it constitutes a win-win scenario for all sides involved. Today's webinar focuses on doing business in the United States, and that will provide you, I hope, with everything you need to know about entering the US market. The webinar provides an overview of the legal framework and regulations when opening a businesses in the United States. We will help you better understand, or at least we will try to help you better understand how the US tax system works, how to set up your business in the US, and how to deal with the 5 biggest legal challenges. And, for instance, which type of visa is most suitable for you and your staff. Also, we will provide practical guidance on how to sell into the US market. This means you will learn about legal framework and key regulation, the most common sales channels, such as retail or wholesale, or the possibility of partnering with a local agent. And also, we will recommend ways for business and brand development. The webinar is brought to you by the European American Chamber of Commerce, who are our official international network partner in the United States. And further webinars about the US market are planned for the coming months. These will include webinars of the US life science ecosystem and also the sustainable energy markets. So if you are interested in the US market and you want to learn more after the webinar, please don't hesitate to contact our Enterprise Europe Network business advisors. You can reach out your local contact point via the Public Enterprise Europe Network website. And let me conclude saying that this webinar is a unique training opportunity for European businesses and innovators. We will stream the webinar live via all major social media platforms such as X, Facebook, and LinkedIn. And there is a proverb that states, a tree starts with a seed, and I'm excited about the possibilities that lie ahead. International is dynamic and vast market, and Europe's technical prowess complement each other beautifully. So by working together and with this new webinar series, I'm confident that we can unlock new opportunities and drive economic growth for the benefit of our companies. So dear friends, ladies and gentlemen, esteemed participants, having the time in mind, I would like to conclude my welcome address and give the floor to our moderator, Executive Director of the European American Chamber of Commerce in New York, Yvonne Bending-Rothschild, who will guide all of us through today's session. So thank you very much. And Yvonne, the floor is yours.
Thank you so much, Natalia, for the kind words. And we're thrilled to be here. And I would like to welcome everyone to the European American Chamber's inaugural EEN workshop. We specially created the programs for our colleagues and counterparts on the other side of the Atlantic to help their members prepare for international expansion. Today's theme, as you said, is doing business in the US, what you need to know about entering the US market. And today's event is organized by the EACC New York office. My name is Yvonne Bendinger-Rothschild. I'm the Executive Director of the EACC New York, and I will be hosting and moderating today's event. And to use your own words, my fellow gardeners are Manny Schönhuber. He's an associate at Jackson Walker. Manny helps European investors and companies with market entry, contract negotiation, and cross-border transactions, as well as dispute resolutions in the United States. We have Ann Coble, a shareholder at Ogletree Deakins, and works with corporate clients in various industries, including technology, engineering, medical, and academic fields, on hiring and employing foreign nationals, as well as with immigration compliance related matters. And we will get to that in greater detail. Immigration and compliance is almost as important as getting the right visa. We are also joined by Johan Bourgel. He's the founding partner of Orbis. And Johan is a French-American CPA. He started Orbis to bring distinctly modern technology-driven approach to tax and accounting services. And let's dive right into the program. Legal framework and regulations when opening a business in the US. Manny, do you want to start and give us a high-level intro, how to incorporate, and some of the critical issues to consider before you get to the United States?
Thanks, Yvonne. Good morning, good afternoon, and for some of you, maybe even good evening. On behalf of all three of us and Johan and myself, I want to thank you for your participation today. And Yvonne, as you said, we'll dive right into it, but very high level at first. To get started, I just want to give you three main subjects that are important to all European companies, investors coming to the US. The first thing you need to know is that as compared to Europe, we're having a different legal system here in the United States. So that's subject number one. Subject number two is the fear of litigation that I see with all my European clients. We don't want to get sued here in the US because if we get sued, similar to the McDonald's judgment we've all heard about, we're going to pay hundreds of millions of dollars in damages. So fear of litigation is actually a very famous word that we came up with in Europe, which is litigophobia, which is the fear of litigation here in the United States. And the third high-level subject, and this is really where most of the meat and the core of the discussion of this subject will be on, are what I call the three pillars of limiting liability. Again, the subject that keeps recurring and what you should remember after this webinar are three main topics here. Three pillars of limiting liability is number one, your entity. You need a corporate structure in the United States. I always advise clients, especially if they're fearing litigation here in the United States, to set up just one US entity that acts as a blocker entity for all claims, damages, lawsuits that could occur here in the United States. So keep that in mind. Set up your entity the right way. Number two is contracts, which we'll also dive into a little bit later on. And number three is insurance. Those three, the three pillars of limiting liability, keep those in mind. As we're talking about setting it up, keeping it on a very high level at first, most of the time you incorporate an entity in the United States that is a wholly owned subsidiary by one of your European parent companies or the European parent company, so that the European parent company and all the assets that you've built with the European entity over decades, or some of you maybe even over centuries, are fully protected from any judicial reach, any court judgments here in the United States against that European entity. And the last point I'll make on this high-level overview is really, what are the main aspects on the legal side you should be concerned about outside of what we just discussed? So it's the question, do you need a corporation? Do you need an LLC? Maybe a limited partnership may even work from a tax perspective, and Johan will talk more about it. But know that you need different types of agreements. In some states, you may need employment agreements here in the US, whereas in other states, you don't. Then what some of my clients are always surprised with is, generally speaking, there's less bureaucracy in the United States. And that really starts with the incorporation process. Nobody has to travel to the United States. You don't need a notary. You don't have to visit, show your passport to start up a company here in the United States. Everything can be done remotely, and it's a very cost-efficient, time-efficient, and quick process. You can set up a company within a week or two if you want to. So that is where I leave it for now, because I know we'll dive more into it as this progresses. So thanks, Yvonne.
Yeah, thank you, Manny. So, Johan, all of this has significant tax consequences. The kind of corporation you set up then triggers a tax in the U. I mean, it influences the type of taxes and you're paying in the United States, but also there's a correlation between the taxes you're paying in the U.S. and the ones your structure in Europe. Can you talk a little bit about that and just give us an understanding about U.S. tax system, but also the correlation to what you're doing in the U.S. and in Europe and how that plays out together?
Yeah, sure. Good morning, everyone, or good evening for some of you. Thanks, Yvonne, and happy to be here for the EACC. So just big picture, and then we can dive into the tax implication of different type of entities and what is the equivalent in Europe, so you understand. I think first the most important thing is to understand the tax system overall, and I would say the mindset and the intention of the legislators on the tax side. There are two main things that are a little bit different than in Europe. Basically, the US, it's closer than the system in the UK, I would say, but totally different than other countries in Europe. So first of all, it's a federal state, so meaning that you have different level of jurisdictions. So that's really important on the tax side, because what it means is that you have mainly 3 levels of jurisdictions, and that for each tax topic, you need to think about, okay, am I gonna have an issue? I'm gonna have the taxes on this each level. So you have the federal level, which is the US government. Usually they always have a word to say on the tax side. You have the state level, and even sometimes, if you're in some jurisdictions, like in New York City have their own tax system as well. And so it's not just, when we say local, it's not just a city, it could be a township, it could be a county, it could be different things depending on the tax topics. Okay, so that's the first point on the tax system, is the federal state system, meaning that you could have different level of jurisdictions for one same tax. And the second point is that we're in a common law system. So obviously there is a tax code in the US, but compared to most countries in Europe, it's much more general. It's much more general, and everything is about regulations and court cases as well. So what it means is that in some topics, you might not have a clear answer. It might not be black and white, like in most topics we used to in Europe. And you might have to, help yourself from professional judgment that, as a CPA or Manny as a lawyer can help you on. And you might have to have a risk approach on some topics as well. So that's a different mindset, and it's really important to have that in mind, because it changes the whole perspective and the whole overall decision making, I would say. So that's for the big picture. Then if we dive into the tax system, I think today we're gonna focus on mainly 2 types of taxes that you're gonna face questions on when you move to the US. It's mainly income tax for your corporation, and sales tax, which is the equivalent of VAT in Europe. So sales tax is a little bit different. We're not gonna deep dive right now, but maybe a little bit later. And so those are the main 2 topics. Keep in mind that depending on your local jurisdiction, you might have additional local taxes, and you might have property taxes, other personal business taxes, and things like that. So it's not just about income tax and sales tax. You might have other type of taxes, but that usually, if you have a CPA, and depending where you move to the US and where you're gonna do business, we're able to help you on that. And so on the income tax side, so maybe I will get back to you on your questions now, Yvonne, on the income tax side. Basically, and Manny's gonna talk about this, I'm sure, later, on the type of entity you can incorporate or form. But just to big picture, you're gonna have 2 types of entities, which are what we call the corporation, okay? And basically what we call LLC LP partnerships that are what we call flow-through entities on the tax side. So what it means is that keep in mind as well that the legal framework, so having an LLC, having a C Corp, could be disconnected to the tax framework. Okay, so for example, a lot of people might form an LLC, but on the tax side, we might decide to actually elect and opt to have this LLC tax as a C Corp. Okay. And meaning that if you're, so me, when I talk about corporation on the tax side, it means that it's not a flow-through entity and the corporation pay its own taxes. So it serves as a broker for tax purposes. And usually most of the European businesses and groups, when they move to the US, they want to have a tax broker. And so they will incorporate a C corporation so that the corporation pays its own taxes. And then if you want the cash to go back to to Europe, then you're going to pay dividends or through intercompany agreements, etc., etc. On the other side, you have the flow-through entity. So the most well-known is the LLC. And this is a flow-through entity, meaning that the LLC won't pay its own taxes, except for exceptions in a few states. They won't pay their own taxes, but the income will flow through the shareholders or the members, and the members will pay their own taxes. Okay. And so usually that's not something that's recommended except in the VC world or private equity world, because if you have an operational company, you don't want, you don't want the US business to be taxed in Belgium or France or the UK or something else. So that's not the most common common scheme. But if money, depending on your cases, money might recommend an LLC on the legal side, and then we can opt to have it as a C corporation on the tax side. So that's pretty much the big picture on the tax system.
Yeah, and just to add one more sentence to that, a major factor in the US is also Nexus. I mean, we will get into that in greater detail later on about the where you are incorporating and I'm getting into the employment on, and where your employees are sitting can make a major difference tax-wise, and when it comes to various types of contracts. Do you want to talk a little bit, just give a high-level intro on visas in this context, and what kind of visas you need for what kind of type of executive, and how those things are different in different jurisdictions?
Yeah, absolutely. So, thank you all for having us. And I think it's really appropriate to have the three professionals that you do have on this panel all together. Immigration actually tends to get left out at the very beginning of planning to move to the US. That is a big mistake. So the more you can plan ahead, who's going to be coming to the US, who's going to be setting up that company. We can work with your tax professionals, we can work with your corporate attorneys to come up with the best structure that works for all of those different needs. So, very appropriate to have us all together. From an immigration side, it is a little bit different than tax and than corporate. It is federal law. So the US immigration law, it is based at a federal level, which means it is the same no matter what state you are going to be, incorporating in and doing business in. The federal immigration law will be the same. Other than that, though, as easy as the US tries to make it for businesses to come here, the immigration system is complicated and challenging, to be very honest. There are limited immigration options for people to be able to come to the US. And in general, the US immigration system is focused on professional roles, so roles that require at least a bachelor's degree, and then also a STEM focus, so science, technology, engineering, math. That is a huge focus for the US right now. And really, all of our visa types are kind of geared towards the professional roles and with a focus on STEM. That doesn't mean that there aren't options to, transfer people to the US as an example that may not have, kind of a bachelor's degree. They just need to be higher level. So, managers and executives. There aren't great immigration options for, like technicians. There may be some options to get people in short term to be able to kind of install equipment and things like that. And there are some creative ways that we can build that into sales contracts to allow for that from an immigration perspective. But overall, kind of the big picture for immigration law is just to keep in mind that the options are limited, and it tends to focus on kind of those higher level professional roles. And really, the sooner you can get us involved, the better, so that we can help with that structure to facilitate those transfers.
Yeah, and one thing that I may want to add, do not hire a European immigration attorney to get a US visa. I see that all the time, and it always goes wrong. Hire a US attorney, and a lot of them work on, it's work on a flat fee, or if you have a group of employees coming over, they can give you the right advice. But it's not just filling out the paperwork, it's actually also getting it through the system. One very important thing, on if I may, and I don't know if you want to comment on that, spouses being able to work. I've seen
Yeah.
so many companies come over here and then the spouse couldn't work, and the executive went back after a year because they couldn't make it happen. Do you want to talk a little bit about that?
Yeah, and actually there's some good news on that front. But well, first of all, I did want to touch on, hiring a European attorney. The US system is very much like US focused. Okay, so US law requires that US attorneys file, petitions on behalf of people with the agency here in the US. So if you're not filing a volume of petitions, you may not know the current trends. Things change depending on the administration. So we live it and breathe it every day. We're filing these all the time. We work with European companies all the time. Just because we don't sit in Europe doesn't mean we're not familiar with, how different countries, operate, and how, honestly, like the different consulates are operating within those countries. Like, for instance, Paris is currently shut down. They closed their calendar through November because of the Olympics and did not give any advance notice of that. So that is a current emergency that we're dealing with right now. Flipping, over to spouses. Two of the most common visas, and I'm trying to keep it high level, but two of the most common visas that we look at when we're looking at options to transfer people in particular from Europe, or for people in Europe who want to set up companies in the US. One is called an L1 intercompany transfer visa. So the L1 is available to managers, executives, or specialized knowledge professionals if the person has worked for a related company outside the US for a year. The other common visa is called an E visa. So there's an E treaty trader visa. It does require that the company have a certain ownership. So say the company is incorporated in France or even traded on the French stock exchange, and then they make an investment in the US. As long as we can show that that company is ultimately owned by French citizens, where it's publicly traded, that's very easy, then you can actually send employees over to the US who share that same citizenship. So, French citizens for a French company, Spanish citizens for a Spanish company, and so on. There has been some recent or relatively recent litigation related to spousal work authorization for people on L1 visas and E2 visas. Those spouses are now authorized to work incident to status. So what that means is that as soon as someone enters the US as an L2 spouse or as an E2 spouse, they get something called an I-94, which is proof that they've entered the US lawfully. It should show L2S or E2S, and that is all they need to work in the US now. So they have actually made it far easier for spouses to be able to work in the US. If you switch to other visa types, though, like the H-1B is one of the most common visa types, We actually try to avoid the H-1B where we can because there are very limited numbers, but spouses generally cannot work on the H-1B, at least until you get to a certain point of the permanent residency process. There's also something called a TN. Every once in a while, we will have people who are dual citizens of Canada and Europe. TNs are for Canadian and Mexican citizens. Their spouses cannot work. And then there's also an E3, which is for Australians. Sometimes, again, we have, UK, Australian, or, people with multiple citizenships, and those spouses are able to work because they're considered E visas. So E and L, spouses can work. Pretty much everything else, they cannot work.
Yeah, major issue. And it illustrates perfectly why we have the three of you on this panel, because it really, the tax, the type of incorporation and the visa, they influence each other to a degree that most Europeans can't appreciate. Manny, back to you and diving in a little bit deeper. Talk to us about the timing of all of this, because the key in my view, and we see that all the time when we're working with companies who are interested in doing business in the US, certain things need to happen on the European side before you can even start the process on the American side. Talk a little bit about that.
Absolutely. And our goal really here is today to get you excited about the United States. There's a reason why we're here, why other companies are excited about this market. I've been living in the United States for 12 years after I moved over here from Europe. And that is really about timing. Now that, Yvonne, you just said it. Timing is, or at least for most of us, seems pretty good right now for a move into the US or an expansion into the US, additional investment into the United States. Now, if you don't have a corporation, a US entity yet, and remember the three pillars of limiting liability that I talked to you about first. We're talking about the first one, your entity now, right? Whether that is a corporation, a limited liability company, a limited partnership. Those are really the three options you have at the outset. And in order to get you excited about the US market, we want to keep it as simple, straightforward as possible and not have too many complexities involved, because as you know, if lawyers and accountants get together, it can get very complex and very expensive right away. So we're not trying to do that. We want you to make the move in the way that makes most sense for you, for your company. And with that, I already said, let's assume, okay, you have your European entity, for example, a German GmbH. You don't have anything in the United States yet. You want to set up a sales office. You don't want to hire 50 employees right away. You just want to get started, tip your toes in the water, get your foot in the door, and enter the US market because you have potential customers here. You may already have done business with them in the past, and now it's time to expand on that. So, of course, you could set up a whole North American holding structure, tax efficient and maximum liability protection, just to be sure the ultimate beneficial owners in Germany, in this instance, are as protected as they need to be. But most of the time, it's not necessary. We still want to do it tax efficiently. We want to protect against potential liability in the United States to really function as a blocker so that no judgment goes back to Europe. But you don't need a whole tree of entities, as you may have heard in the news what other groups of companies do. So let's assume we're fine with just one US entity to get started. Timing is right, we already said. Now you have to choose in which state you incorporate. And this is a little bit of a misconception in Europe that I hear with clients. It's not about the question where you will locate your office, where you will locate your employees, where you're generating your sales, where your customers are located. Yes, those are all business decisions on where you should probably put that sales office, put that greenfield investment, a warehouse, whatever it is. But that does not mean that you have to incorporate, set up your corporation in that state. The misconception is that we're only using the laws of that state of incorporation as the governing laws for your US company. Now, it's been all over the news recently with Elon Musk again about the move from Delaware to Texas for SpaceX and potentially Tesla. Of course, Tesla, I'm not sure, but I assume there was never really an office in Delaware. They just used the laws of the state of Delaware, which approximately 90% of all companies do. That's the business of the state of Delaware here in the United States, to host corporations, and they make a lot of money with it. You can imagine it almost like a PO box, a post office system, and don't misunderstand it to like tax efficient systems in the British Virgin Islands or Panama. That's very different. So Delaware is just usually also for many European companies the chosen state of incorporation because it's a very business friendly state and the laws are favorable to businesses. Now, if you decide to come to the US, a big mistake that I see a lot of companies make is, okay, well, we want to set up in California, for example. Why don't we just use the laws of California to incorporate? I always say the best idea to incorporate is in a business-friendly state. California, as you may or may not know, is not the most business-friendly state. That's why there's such an exodus out of California into more business-friendly states, like, for example, Texas, Florida, the Carolinas. Generally speaking, you can say the southeast and generally the south of the United States is very business-friendly, and the laws are very business-friendly. At the outset, I said, don't forget, we have a different legal system here in the United States than we do in Europe. United States law, generally speaking, is based on the British common law, whereas European Union law or Central European law in general is based on the French Code Civil or the Napoleonic Code, which is why the law books in Europe are this thick. And in the US, we don't really have that many law books because from state to state, it really depends on where you are. But statutes are not as common. As Anne already said, there are federal laws, yes, that's especially in the on the immigration side, as well as to a certain extent corporate side, they govern the entire United States. But quick pop quiz, there's one state in the United States that has a Napoleonic French Code Civil based legal system, and that is correct, Louisiana, because of the French heritage. So all the other states use, generally speaking, the common law system. So with having that said, most of the time you incorporate in a state like Delaware, like Texas, like Wyoming, like Nevada, use those laws, you will have an official address there, but then you just move to wherever you wanted to move in the first place. And you'll have your office there, you have your setup there, and employees, whatever it is. You just, after the incorporation, have to register, for example, your Delaware corporation with the state of New York, because that's where your office is. You have to register with the secretaries of state there. And the timing, last thing, then I close it out and hand it back over to you, Yvonne. Setting up a corporation is very straightforward. All we need as a lawyer is, obviously, you have to pick a name, XYZ North America Inc., for example, XYZ USA Inc. Then we have to name the directors and officers, like officers, for example, CEO, president, secretary, treasurers. And last but not least, you need an address. Nobody has to come over to the United States. You don't even need a visa to set up a US company. And you can handle everything remotely. And timing is, again, a couple days, depending on the state that you pick, up to a week. One thing that takes a little longer, and that may now be the gateway into Johan's discussion, is the EIN, the Employer Identification Number, which is, in layman's terms, the tax number of the US corporation, which is what you need to, 1, open up a bank account, and 2, hire employees.
Yeah, and here we are with a bank account. I mean, you need to camp out in front of the bank in order to set up a bank account. That can take weeks and months, in some cases. But and one thing, I hear what you're saying about California. The thing though with California is that Californian laws oftentimes swap over to other states. If you're selling to California, you're still obliged to comply with the laws of California. So you won't get away, from California entirely, no matter where you're setting up. But Jan, taxes. You already alluded to or mentioned some of the taxes: income tax, state tax, county tax. Do you want to give another overview of the how structuring can use to optimize tax levels and withholding implications?
Yeah, sure. Maybe I want to make a quick point first on the bank account, because I think that's really important. As Manny said, you can set up you can incorporate your corporation pretty quickly, in a matter of days or weeks. But usually the tax number will take a few days as well. But no, during COVID, the IRS was really backlogged. No, it's back to normal, so it shouldn't be an issue most of the cases. But the bank account, that's why you might have some issues, because you have FATCA regulations where the banks, when you have a foreign ownership, the KYC process, what we call know your customer process, they need to comply with FATCA, and it could take a long time. Yeah, it could take a lot of time. So, and on the accounting side, because I'm a CPA, I can talk about tax, but as well on the operation side, what we have seen in the past as well is sometimes you're gonna open a bank account in a big bank, and their compliance system changes, and then they send you a letter so that you have to close the bank account within 60 days because they don't want to have, foreign-owned businesses. It's too much compliance for them. And so that's why we talk this out with your CPA and your counsel, your accountant, because there might be some strategies on having different bank accounts. So if anything like this happen, you're not just, you already anticipated that. And back in 2012, with our clients, I mean, it was like half of our clients from Chase, for example, that we had to move them to someone else within 60 days, which is like pretty short. So bank account, it's a big topic in the operation for me. So keep that in mind. I'm moving back to the taxes now. So what I was saying is that so you have mainly two types of taxes. To be simple, you have the income tax and the sales tax. Income tax, wherever you're incorporated, that's what Manis was saying. You could be in Alaska, Delaware, California. You're always going to pay the federal income tax. Okay. As of today, for corporation, it's 21%. So we're pretty much on the similar rates as European countries. Okay. But then you're going to have state level tax and maybe some cities tax, especially New York City mainly. So that's where the complexity could be. It's how do you determine in which states you're going to file? Because obviously, if you move to the US and you didn't make any sales and you just have few employees and an office, there will be a lot of compliance to have to file in 50 states. It would be unreasonable. So there are constitutional limitations that turns around what we call nexus. Okay. And it's the same for sales tax. The difference with sales tax is that sales tax is not regulated at the federal level, it's regulated at the state level. So you don't have a federal sales tax, you only have state sales tax. Okay. And so to know for sales tax or income tax in which states you're going to have to file and collect taxes and remit taxes to the states is based on a constitutional limitation, I would say, that's called nexus. So the nexus comes from the Latin, which means connection in Latin. And so what it means is that a state and a jurisdiction overall has the right to tax you and to require you to be taxed in their jurisdiction if you have enough connection with them, enough connection that makes it for them the right to tax you. And how you determine that, it's based mainly on two concepts, which is physical presence. What it means is that if you have an employee, an office, if you have inventory, sometimes it could be if you have some agent in a state, then it's considered as having a physical presence. Okay, so in this case, the state is you will have what we call a nexus in the state where you have your employees. So for example, in New York, let's say, and so you're going to have to file taxes in New York. Okay, so that's the first concept, physical presence. The second one is what we call economic presence. And this one is really important because if you look at the court cases in the past, it becomes more and more important. And actually, if you look at the international tax systems, the nexus and the economic nexus becomes more and more important internationally as well. I mean, I'm a French CPA as well, so I've seen the French government trying to apply a economic nexus tax on Google and all the GAFA, the Facebook and all of that. It didn't work, but even European countries are going more and more that way. And so economic nexus, it's mainly, even though you don't have a physical presence in a state, depending on the level of amounts of sales that you have from customers based in those states, to make it simple, then if you reach those threshold, the state will consider that you have this economic threshold, this economic nexus, and that you're required to file in these states. Okay, so that's why it's really important to have a follow-up on the sales that you make in the US by state. So it's really important to look at it on a recurrent basis so that you don't miss deadlines, that you don't miss tax requirements. Okay, usually what we recommend when you start is at least to look at the sales by state, at least on a quarterly basis with your CPA, so that you just do a quick scanning on the sales by states to see if there is additional requirements or not for the next quarter.
And also
and so
payroll, no? Payroll requirements and withholding plays into that.
Yeah, exactly. I mean, payroll, it's much easier because it's only physical presence. It's where you have your employee. So if your employee is a resident in New York, then you know you're gonna have to withhold income taxes for this employee and social charges as well, and the employer social charges from these states. But that usually it's easier to anticipate because nobody does their own payroll themselves. Like in most countries in Europe where you can do it, you usually go through payroll platforms. And usually if you're not set up properly in the States, it will not allow you to do payroll. So it's pretty straightforward once as part of the setup of the payroll platform. So that's the payroll, it's the same concept, but it's much easier to anticipate.
But if you have like, we talked about it in the preparatory call. So you have mobility policies. You allow your employees to work from anywhere. All of a sudden, you know, a Florida employee shows up in New York, and then for I don't know what the threshold is for 30 days, and then you become liable for New York city resident tax.
Yeah, so actually since COVID it has been a big topic because in Europe we used to what we call global mobility issues between different countries, and actually in the US you have to picture it as Europe basically. You could have global mobility issues intra-state, and so that's a big topic because especially now with remote work, which is pretty common in the US. You know, you have employees that can go work remotely in California for 2 months, then they go in Colombia for 3 months, and then they go in Alaska for 2 months or whatever. And so how do you manage that? And why now there is no, each states have their own rules. So some states, they will have days of presence threshold. So if an employee is present more than 15 days, then you are required to withhold taxes from these states as well. In some states, it's much more court cases and much more analysis. You have to take your own decision on at what point you start, you know, withholding taxes, payroll taxes on those states. So there has been some regulation projects at the Congress. And if you look at the international regulatory bodies about international global mobility as well, and you look at best practices and what as professional we do, usually we consider that if an employee spends less than 30 days in a state during a year, the burden of being compliant for those states will be much more will cost you much more than being compliant, basically, and if you get a tax audit. And for a state to assess you if you have an employee that's spent less than 30 days in a state, it will not be worth for them as well. So usually the best practice is to say, okay, maybe in your global intra-state mobility, look at this 30 days threshold, because that's where below that we as a professional, and that's where we think the risk is really limited, except in 2 states where you can have some issue, which are New York and California. New York and California could be really aggressive states when they audit you. So that's why you need to be careful. But usually those states, it's most European companies, it's big hubs for business. So usually that's where you're going to be registered anyway, because you're going to have employees most of the time. But New York and California, everything related to taxes, it's a red flag, and you need to anticipate everything. But otherwise, yeah, the recommendation is to look at your global mobility, not just internationally, but as well intra-state, so that it's clear for everyone and that you're not responsible for, if an employee goes to another state and doesn't inform you, so that there is a clear policy within the firm and that you don't have any issue on the payroll tax side.
Yeah. It makes me come back to contracts, but before we do that, Anne, your comments on that, bringing European employees in, let's dive in a little bit deeper. And I have a question from the audience. It sounds easy to set up a company in the US from overseas, but having done that, is it possible for an entrepreneur to get a visa and operate his or her company there? I mean, it's kind of, you need to, get the visa taken care of the moment you're setting up the corporation. If, to start with that question,
Yeah.
could you get into the B visa issue? Everybody's coming over here,
Yeah.
handing out business cards.
Yes,
and
yes.
Making my skin crawl.
Yeah. So, many Europeans are eligible for something called ESTA, which is, you apply online, you get approved, honestly, really quickly, like 24 hours. You don't need to go to the US consulate and get a visa to come to the US. And so people will essentially use ESTA and travel to the US very frequently to set up their business. The rules around ESTA, though, and I think part of that, part of why people get into trouble using ESTA is because it is so easy for Europeans to come in on ESTA. You don't tend to get flagged at the airport. They just tend to wave you through, and they're very friendly until all of a sudden they're not. And with ESTA, you have to be very careful. You are only permitted really to, attend conferences, receive training, so not give training, receive training, or have business meetings. Okay. And frankly, the more frequently you travel to the US, the more likely that you are going to get flagged by a Customs and Border Protection officer when coming into the US. One thing that they have gotten very savvy about asking and has landed some people, including some very important people with very, that work in very high level positions with very well known global companies, is, do you have any people in the US that you manage? If you say yes, they will turn you around and say you need a work visa to come to the US. Because even though you may be coming to the US to just have meetings with those employees, because you manage them, when you have those meetings, you are doing productive work for the US company and you need a work visa. So, you can come to the US and, have business meetings to try to set up that, structure, that framework to get customers. I wouldn't recommend that you're handing out business cards with the US company name saying you're like the CEO of the US company, because that becomes an issue. It starts to look like you are working in the US instead of having meetings. You could do that for the European company, and it is fine to have those meetings in the US. Once you start looking at really setting up a business in the US, potentially hiring employees, even if you're in the very early stages of setting up the business, but that you personally want to be able to come to the US to kind of work in the US and to really have an active role in the US company, there are visa options for that. Just to set an expectation on timing, the visa process is lengthy. It depends on, in a lot of circumstances, the US consulate appointment availability, where you're going to be applying for the visa to come to the US. So, like I mentioned, Paris is now closed until November. So, if you are coming from France and you want to set up a business in the US, you may not be able to get a visa stamp appointment until later in 2024. Other countries, they have better availability, but you just have to be prepared. There is some fluctuation. If for people who are going to be owners, operators of the company, there are some limitations from a US immigration perspective on the types of visas that allow for owners to get visas. So like an H-1B, it's not for self-employment. So for the kind of owners, entrepreneurs, we often will look at an E-visa, so that treaty trader visa. To get an e-visa, and this is always the problem, it's like the chicken and the egg problem with e-visas. So to get an e-visa, you have to show that there is actually money at risk, okay? And the amount of money is not set in stone. It's not anywhere written, in the regulations. It depends on the business and honestly, like the valuation of how much it's going to take to get that business up and running in the US. For purposes of this discussion, let's say it's like $100,000. Having $100,000 sitting in a US bank is not at risk. If it's just sitting there, there is no risk. You have to have, shown you're like getting a lease, you're buying equipment, etc. The challenge is there comes a certain point where you cannot do that on ESTA and you need the work visa. So it is a very fine line, and you'll want to work with Immigration Counsel closely if you're working through that e-visa process in particular, so that you are not crossing over the line with ESTA, but you get far enough along in the process that you actually do qualify for the e-visa. But just from the question, if you're going to be kind of like the entrepreneur setting up the business, the e-visa is likely a good one to look at just for an initial kind of thought. There is that L1 intercompany transfer too, particularly if the European company that is going to be related has multiple owners. That could be a good potential option as well. But there are some challenges with the L if the business in the US hasn't been operating for at least a year. So sometimes the E is better for newer companies.
Yeah, it brings me back to what we discussed earlier. It's all a question of timing, and it's kind of like a jigsaw puzzle. All the pieces need to come together. You can't start payroll or pay yourself or pay rent for an office, even if it's a shared office or whatever, a WeWork or what have you. If you don't have a bank account, you don't have a bank account. If you don't have a New York address, because I think even for an office bank account, you need to have some utility bill and all of that. So asked. I mean, we are hoping for this webinar to help you enable you to ask the right question, but get counsel. Don't try to do this by yourself, and with the help of a friend, especially not the visas, definitely not the taxes. And Manny, I would like you to go a little bit more into the contracts, the various contracts that you need, employment and the others. Can you just give us an overview and why it's important to make sure that you have all of these contracts in place?
Certainly. So this means we're moving over from the first pillar of limiting liabilities to the second pillar of limiting liabilities, which is contracts. Again, but you want to keep in mind that we have a different legal system in the United States than in Europe. Generally speaking, we don't have a uniform contract system for the sales of goods. Yes, there's a statute, the UCC, but not all 50 states have either adopted it, copied it, updated it, changed it, ignored it. So it's really different from state to state on that level, which means I always cringe a little bit when clients say me, well, we have terms and conditions in Europe. They're already translated in English. So let's just say applicable law, United States. And then we'll just use those for nationwide sale in the United States. And while we're at it, let's just use them for Canada and Mexico as well. So that's obviously big red flag, big no-go. We have the freedom of contract here generally in the United States. So whatever you put into your contracts, whether that's terms and conditions, an employment agreement, any type of contract you can think of, selling goods, acquiring another company, whatever you put into those contracts governs the relationship between the parties, unless and until a judge or a jury says otherwise. And as you can imagine, in order to get to that point for a judge or a jury to disagree, it costs a lot of money in the United States. Again, fear of litigation, right? We don't want to get involved in it because we want to be efficient with our time, with our resources, and make sure the US entity is set up the right way to succeed. So what are some of the main contracts that you should be concerned with? Obviously, if you're selling a good or a service into the US market, use terms and conditions. Or if you have a specific customer that you're selling them to, sale of goods agreements or sale of services agreements. Stuff like that. Similar goes with your office. If you're leasing a space, if you're acquiring a space, warehouse, whatever it is, you want to put that in writing. And please, another thing that you should take away before, especially as you get started in the United States, don't sign a contract without letting your lawyer at least do a cursory review of the contract. It doesn't have to be a full-blown red line, but the main reason why you should do that is, again, we have a different legal system. And yes, everybody who's on this call can speak English. The business executives in Europe, they understand English. They know what to look for. They may have negotiated contracts globally, but just approach it the right way. Don't approach the US market. That goes for everything, whether it's the tax, the immigration, Yvonne, you just mentioned it. Don't do it yourself. Don't enter the US market on the cheap. Yes, it is generally speaking a more expensive market than we all know in Europe, but the risks are also higher. So with your contracts, with your terms and conditions, you'll also see that most of the time they're lengthier than what you have in Europe. Because again, freedom of contract, we have to put certain provisions into contracts that you may not be familiar with in Europe that are specific to either, for example, California, a certain state, or the United States as a whole. And if it's not in your contract, usually it's not assumed. A judge will not look at, they usually only look to they call it the four corner rule. They look to the four corners of the contract, what's written, what did the parties agree to, and it's not, well, what was the intent, or let's fall back on a certain law. We don't have that in the United States. So don't just use your European contracts, translate them into English, work with your lawyers on it. I know at the outset, it is a certain expense that you have to be aware of. But what we also do, again, to be efficient with your time and your resources, I personally ask my clients to send me what they already use in Europe and the rest of the world. And then we're not starting from scratch. All the economic terms, whether it's a sale, whether it's even an employment relationship, there's certain benefits they want to offer. Let me know what you already have, and I can see what I can do with them and adapt them to the US market. So terms and conditions, any transaction that is a sale of a good or a service should have a contract, because most of the time, if something ends up in litigation and you have to sue a customer, for example, because they didn't pay you and you're owed a lot of money, then we always prefer to have an actual contract in it. Governing the relationship, and not just rely on invoices, because then it's a he said, she said kind of situation, and we have to work with witnesses. And then, as it usually goes, stories change, people forget, and then it gets very expensive at the end. So with the contracts, keep that in mind. Use your advisors to your advantage. Don't do it on the cheap, but have contracts for relationships and business relationships, employee relationships, and transactions in order to, again, protect yourself, number two, against liability. And if liability, this is a little tidbit that I give all my European clients, so this is free legal advice now for everybody on this call. If you have the opportunity to dictate the terms and conditions of the business relationship, especially as a foreign-owned entity, I am a big fan of having arbitration provisions in the agreement instead of having to go to a state court in eastern South Carolina. No offense, but for example, right? It is you're going to fight an uphill battle, and I've been there. I started out as a litigator working with European companies, representing them in court here in the United States. What's the other side going to do? Oh, look at this meme European company taking away our jobs and qualified labor, sending them over on visa. Americans could have that job. So you're always fighting an uphill battle. But if you're in arbitration instead, first off, you're not in front of a jury. Second, we, as the lawyers on both sides, can agree on an arbitrator, that it's the final decision maker. So obviously, we're going to pick someone who has experience with that, who is not listening or governing over a family dispute, a criminal dispute, and now your employment dispute, for example, an hour later. So we want somebody with experience, and you have control over that. And the final point with that is because everybody's afraid of the costs, right? And I know litigation, whether it is litigation, a lawsuit, or an arbitration, it is expensive in the United States. And the American rule, which is also different from Europe, usually says, it is actually called the American rule. Each party has to pay for their own attorney's fees. No matter you win or you lose a case, you have to pay your attorney's fees. But in your contracts, in addition to the arbitration provision, you can put in a prevailing party attorney's fee provision. That means if you're winning the case, and even if you're just winning $1 in a payment dispute, if the other side has to pay you money and you have a prevailing party provision, attorney's fee provision in your contract that is enforceable, the other side also has to pay your attorney's fees. And this is something that can only be contractually regulated with your contracts. Most of the time, I just put that provision into the terms and conditions of my clients, or with a statute. For example, there's some statutes that say, okay, if you're prevailing in a case under the statute, yes, then you get your attorney's fees. But if not, and you don't have that provision in a contract, you have to foot the bill at the end of the day without it. So keep those things in mind. Have American lawyers or US educated lawyers look at your contracts. Every relationship, business relationship, should be governed by a contract. Think about arbitration as a potential benefit as compared to in-court, state court litigation and prevailing party attorney's fees. That should be in your contract if you can put it in.
Thank you, Manny, for that. And then everybody thinks you can hire and fire your employees in the United States. The answer is not so much. Everyone who works at EACC New York has an employment agreement. So what can you share about that?
Yeah, so I think that that's one big difference between Europe and the US. We see a lot with European companies, they'll be like, well, we don't have an employment contract yet. We can't start on the visa work till we get that employment contract. From a US legal or immigration perspective, that is not actually required. In general, Europe tends to be very much more protective of workers than in the US. That doesn't mean that you get to just hire and fire people at will. Manny and Joanna have kind of touched on this. Different states have different laws. So you also want to engage if you are thinking about terminating someone or even thinking about hiring someone. You may need to engage with employment counsel. And so employment legal counsel to make sure you're set up appropriately, that you're not, facing any specific risks. California is like its own country, so good luck trying to fire someone in California. But employment counsel specializes in the different states. Ogletree, for example, we have a very large immigration practice, one of the largest in the country, but also we're a labor and employment firm. So I know it's a lot of lawyers, but it really does vary based on the state, and we each have our own specialties. So that's just kind of something to think about as you grow your business in the US and are, bringing on employees, even US employees, their employment law concerns. From an immigration perspective, if you have gotten the visa and you're coming to the US, or your employee's gotten a visa and they're coming to the US and you're so excited to have them here and for them to get started working, and you're like, okay, now we need to get them onto payroll. Where is your social security number? Social security numbers can take weeks to get in the US. During COVID, it could take months. And this is kind of a combination tax immigration issue. So from an immigration perspective, you actually do not need a social security number to work in the US. You do have to be physically in the US and have your visa to even apply for a social security number. However, many payroll systems require the social security number to get them set up into the system. Sometimes there is a dummy number to kind of bypass that, but for tax reasons, people don't want to do that, or companies don't want to do that. And then also, you can't get a bank account without a social security number. So sometimes there is this kind of lag period, even once people get a visa and come into the US, before they can get a social security number and really kind of get set up to do business in the US, to be put on payroll, to get benefits, and to get a bank account, frankly. So you want to factor that in when you're transferring people over. I'll let Johan talk about the specific tax issues that come up with this, but one strategy that companies will often use in these situations is they will keep people on foreign payroll for this short period of time until they can get them moved over to US payroll. So right now I would say it's like 3 weeks to 4 weeks to get a social security number, so it's a relatively short period of time. So that's one strategy. Sometimes people will come in and apply for a social security number and then leave again. And then they won't come back to the US until they're really ready to be onboarded. So just some things to think about. Immigration does make it a little bit more complicated, but there are always ways around everything. And this is also why you engage with local counsel, because we have dealt with these issues before and we can help you navigate around them.
Yeah, very good. Johan, what do you want to add to the topic? And
Yeah,
just timing wise, we have 17 minutes left.
Okay, thank you.
And we have one more big topic.
Okay, well, on the social security, I think it depends. So it will depend a lot on your industry. So it's like the banks, the payroll providers. Some of them are focused on specific industries, and so you can bypass some requirements sometimes. So it's kind of a case by case basis, and it depends on where your employees, what states they are. I know in New York, if you go to the Wall Street Social Security office, you can go anytime at 7 a.m. They open. During the week, you're gonna be the only one there, and so it would on some states. If you go to Miami, it can take 4 or 4 weeks, as Anne was saying. So it would depend on your industry, what type of payroll you're gonna set and platform you're gonna use, and as well where the employee will be. But there are always solutions, foreign payroll, or having being on the local payroll for without Social Security. In some cases, we can do it. It's kind of a case-by-case basis, but there are always solutions anyway. And the idea is that we choose the solution that's best for you and that we give you the less risk as possible for you. So that's pretty much pretty much it.
Yeah, I have a question from the audience. The gentleman has a service technician hired from his office in South Carolina, but he mainly works at customer sites all over the US. And the question is, where does this person pay income tax? Is it South Carolina only or also in other states?
No, so by default is clearly a resident in South Carolina, because that's why he has his family, that's where he lives, that's why he has his main home available. So he's a resident in South Carolina. So whatever happens, he's going to pay tax in South Carolina. However, he might if he spends too many times on the state, he might have to spend, some time. If he spends a 3-month project in New York on a client, he's gonna have to pay taxes in New York on those 3 months. However, there's not gonna be double taxation. It's like between Europe, most countries in Europe and the US. If you pay taxes in one state, the employee, if he pays taxes in one state, is gonna be able to take that as a tax credit on South Carolina. So he's gonna pay the whole tax for the whole year in South Carolina, but whatever he paid in New York will be deducted as a tax credit from the taxes in South Carolina. So in South Carolina, he will only pay the difference. But just to simplify, that's pretty much how it will be. But yeah, if those service employees or those like sales rep, that could be an issue, and that's why the mobility and even work mobility policy is really important to set up and to have within as part of your HR documents, kind of.
Yeah, and it gets us right to our next topic, sales channel. Are you hiring your own sales team? Are you working with a distributor? Are you hiring an agent? Manny, can you just give us an overview over what the different options are legally and what people need to know about them?
So at the end of the day, it really depends on your risk appetite, I always tell clients, because on the one hand, you can come over here to the United States, set up US entity, go all in, hire your 5 to 10 sales employees, whether that's a full-time employee or independent contractors. There's different options to do that. But at least you want to put some meat on the bone, so to speak, for your US entity, and have for different regions, different employees covering those regions. Another option, obviously, and Yvonne, you said it, would be to work with a distributor. I have clients that do that as well, where they enter into a distribution agreement with a US company that is going to handle the US sales. Now, I understand there are economic as well as some tax concerns why you may want to do that with a European entity, right? But just remember that if something goes wrong and there has to be a lawsuit over the distribution agreement, you're going to have to enter that lawsuit with your European entity if you don't have a US entity. That means all the European assets, again, are on the line. So that's why, I mean, what's your risk appetite? Another option that I've seen clients do more and more so now, if they are just not fully committed yet, or they want to take advantage of an existing customer relationship, partnership, however you want to call it, is a joint venture structure. They say we enter into a partnership, a joint venture with a US entity. They are going to, which can be a supplier, a customer, and this entity will then sell our goods, our services into the US market, which is great idea at the outset. And I said it gives you the comfort that you need. You can tap into an existing network, but it's also risky because unless you holding 51% or 50.001% of the joint venture entity, which has to be created, you don't have control over it. And what happens if you don't have control and you're fighting in a 50-50 partnership? It's like you're in family court, right? It's like a divorce. It gets nasty, highly emotional, and very, very expensive. The only ones making money in a split up like that are the lawyers and the advisors. So be aware of those. And I try to tell my clients, if you're considering a joint venture, whether that is to enter the US market, to expand into different territories into the US market, try to have control. Try to get those 51% because you're also the one providing the product. And then they're just reselling it into the US market. Have control over it. That'll prevent a lot of potential headaches down the road. But in some, we got joint venture partnership structures, we got distributors, and then you can do it on your own, which may take a little longer, but at least you have full control over everything.
Johan, are there any additional taxation issues that arise with that you want to mention? We talked about the multi-user tax, sales tax certificate earlier.
Yeah, first of all, I think it's when we talk about the distributor from a European company, you know, on the tax side, there is no much issue here. Where I see, because you have a distributor responsible for distributing everything and selling everything in the US, so that is responsibility. So there is no, the inventory is on, you know, you sell the inventory to him. So there is, most of the time, there is no much tax issues. But however, it's important that you talk to your CPA in the US as well to make sure that you don't have a permanent establishment with the in the US, so that the foreign company doesn't have to file any taxes in the US, basically. However, where we see the most issues, especially in the retail and software industry, is sometimes the clients, they are not sure about entering the US market, so they're going to do business from the European entity from Europe directly. So basically, they're going to have, you know, like fashion industry, they're going to sell online through the US market, ship everything from France to all over the US, or, you know, provide the software solution, you know, from Europe to US customers. So there is no income tax issue on that because you don't have a permanent establishment in the US. However, there could be a sales tax issue. And that's where it's not because you're a foreign company that you're not required to follow sales tax regulations in the US. And why? It's because sales tax, there is no federal sales tax, it's regulated at the state level, and there is no sales tax treaty between the states and the actual European governments, you know. And so basically either a domestic or foreign entity should follow the same rules for sales tax. And that's where it could be really tricky, because even though you don't have physical presence, you can reach those economic nexus in some states where that will require you to collect sales tax, even though you're a foreign entity. And that's why it could be dangerous, because you're on the hook with the state tax administration, and you don't want that, especially with California and New York, as I said. You want to be clean because they could be really aggressive. And so that's for me the main topic. However, especially in the software industry, there could be some complexities. That's what I was saying, the multi-user, because even though if you sell your software solution to, let's say, Google, who's based in California, actually the sales tax that applies is not necessarily California. It's where the users of your solution are located, okay? But however, you don't necessarily have the control on where are Google's users using your solution, you know? And so that could be really tricky. And so there is a lot of procedures into sales tax where to know the user, you basically need to ask Google if they have a multi-user certificate. And that, if you don't ask the question, you could be on the hook for any states, you know, in the US for sales tax. And so what's really important, and that's where the collaboration work between the lawyers drafting the terms and conditions for the US market and the CPA on the sales tax issues are really important, because they're gonna, for you to be off the hook, basically, we can include some provisions in your terms and conditions that will basically make you not responsible for all those issues, that even though you sell from your foreign entity or for your US, from your US sales. So that's really important. Those issues are the one that we see where there are the most issues. And so they're really important to keep in mind and to raise to your advisors.
Yeah, thank you for that. We won't have time to get into IP protection, but we have another program on that. So I will skip that for now. But a few words on business and brand development. I think one of the things that I always see, have a can-do attitude and not a can't-do attitude when you come to the US, and many I see are laughing. And another thing is really prepare your sales approach and your brand for the US context. There are a lot of cultural differences in how certain names come across. There are certain understanding. We call it Americana. People who grew up in the U.S. Can laugh about certain things that implants like Manny and myself or Jan have no idea why everybody in the room is laughing. But again, the thing is, get advice, get someone here who can help you. You can hire your European advertising company, but have somebody here who is at the least a bouncing off board, who can speak the language, so to say. Manny, is there one comment you want to add to that before we go to the last question?
Yes, I completely agree. And I would say it's all about mentality, right? Don't approach an expansion into the US like you would approach an expansion from Denmark into Sweden or from Spain into Portugal. Although we, again, understand English very well, Western cultures do business alike, it's still, especially on the branding sales side, let the Americans do the selling. It is very much network-based selling in the US. In some states, even a good old boys club, you have to pay to play. So be aware of that. Protect your brand by just that one comment, Yvonne, which is very important. Don't forget to register your IP, your trademarks that you have in Europe, also in the US and North America. That's very important. But other than that, Americanize as you approach the US market.
Yeah. And we have a quick roundabout. 2 things you need to succeed from each of you. Johan, 2 things European companies need to know, to do, to succeed.
Yeah, for me, it's the mindset. As Manny and you are seeing, the mindset is you need to approach it with the American mindset. And so that's really important. And for me to bridge this barrier, the best advice I would give is talk to your peers in your industry. Talk to your peers in your industry that already made the move, because there is nothing better than talking from experience, and also not be scared to make mistake. Know that you will make the mistakes anyway. And what matters is the big picture and the long term. And so that would be my few advices and my last 2 words.
Anne?
I think from an immigration perspective, just plan ahead. So plan ahead from a timing perspective. Know that however long you think it's going to take, it will likely take longer. And I think just realize that there are creative immigration solutions. So we may get partway through a visa process and then decide we're going to pivot and try something else. That's okay. You want to work with immigration counsel that, is familiar with various visa types and can actually help you be creative. There are generally immigration solutions for people that we can come up with. It may not be your ideal, but there are lots of options. And so just be, flexible and also just, open and aware of kind of the timing and just legal constraints where it comes to immigration.
Manny, last word.
The beauty about all our jobs here, whether it's myself, Anne, or Yuan, or even the chamber here, is we see many different European companies enter the US market, some successful, others not successful. And I at least claim that there is a secret to success. And part of that secret to success is that you need a team. I have a soccer or football background. I do everything with a team approach. And the team that you put together for US market entry is going to guide you through that process. And I call them the core 4. You have 4 key advisors that you'll need. Selfish plug, obviously, you should have a lawyer, right? You should, the second one, be a CPA, because you may be wondering why is there a lawyer and a CPA in this webinar? Because the law in the United States actually makes it clear that lawyers are not giving tax advice and CPAs are not giving legal advice, which is different because in Europe you can go to your advisory firm, you get the tax and legal advice under one roof. Here it's different, which is why CPAs and lawyers need to collaborate. The third of your core four is your banker. You need a good banker that can set up who's familiar with the European system and can set up the entity and the bank account, so to speak, to your advantage. And last but not least, which also closes the loop on the three pillars of limiting liability, is your insurance broker. Don't do business in the United States without insuring the US entity and having insurance coverage. So those are my pointers combined as the secret sauce. And with that, again, on behalf of Anne, Joanna, and myself, thank you for taking the time to spend this morning, afternoon, or evening with us. And obviously, we're available, happy to answer any questions afterwards. Also, thanks to the EACC for putting this together, for inviting us, for asking us to speak. And I hope you had as much fun as we did and learned a little bit from all the information overload that you were provided. So thanks, everybody.
Yeah, a big thank you from me as well, and to the team at ESMA for allowing us to do this workshop. To our audience, I hope you found the information valuable. If you have additional questions, you can always email us. I put my email into the chat, and we will be happy to help with additional questions. Be sure to chime into our next program, Thursday, the 21st of March. Our programs are scheduled for the third Thursday of each month. And the next program will be hosted by EACC Texas, and will cover the US startups ecosystem. And with that, I hand over to Crispin, the Deputy Head of Unit at the European Commission.
Thanks very much, Yvonne. Thank you very much, colleagues. This has really been a fascinating event, and it was a happy event for me because I spent 7.5 years living in the States, always in Washington, D.C. And when you said it's a different market and a different country, I can only underline that. I think even as a Brit, sometimes we underestimate just how different a mentality it is in the US in all kinds of beautiful ways. It's and that is the beauty of engaging, and so I think it's been really great today that I saw we had 137 people at one point, and that's a testament to the interest. So I would really like to thank the European American Chamber of Commerce for setting it up. I'd like to thank Thomas and Eric and the Internationalization Thematic Group for also setting this up, and also the series. Just to underline, we in the Commission and DG Grow, we're really committed to this. We think there are huge opportunities out there. It's a really good market. The economy has stayed strong, and that is irrespective of who's the president. That's been one of the constants. And I think, don't be, whatever our views on the political situation, we saw a remarkable economic stability between Trump and Biden. So whichever one of them wins, don't be concerned. And then, at least from an economic point of view, let me add. But really, I encourage you to seize the opportunities, really get out there. I've learned a few things myself. Liticophobia is a new one on me, Manny, but thank you for that. And as you said, we really need to get excited about the US and getting there. So really, I encourage you to use to use your partners in the US, including obviously the European American Chamber of Commerce and EN-US more widely. Yvonne, you've talked about the next webinar. By the way, it's which will be on the 23rd of March. We need to a little bit check the timing at the US end, because one of the ways that the US is very different is that you move to springtime about 3 or 4 weeks earlier, which always catches people out. So we'll check that the timing is right. And then more widely, we have a wider Embracing Global Markets webinar series, which is 8 monthly webinars. And we also have an upcoming event organized by our colleagues in DG IMPA on mutual recognition agreements, and that's taking place next week. That's taking place a week today on the 29th. at 10 to 11 Brussels time. So with that, a big thank you to Yvonne, to Manny, to Johan, to Anne for your real excellent insights. And thank you, colleagues, for your excellent questions. And with that, I close the meeting.
Thank you, everybody.
Thank you. Have a good day.
Thank you.
Bye.
Thank you. Bye-bye.
Thank you. Bye-bye. It
Thank
was a
you. Bye-bye.
pleasure. Ciao.